All right, looks like we have both counsel connected, so we'll go on the record in Haley Vander Kirchhoff versus Nicholas Vander Kirchhoff, file number 2419800. If I could have counsel put your appearances on, starting with plaintiff.
Reagan Richards, Legal Services of Northern Michigan, appearing on behalf of plaintiff Haley Van Diekerchow, who is also via Zoom.
Good morning, Your Honor. Elliot Blumberg on behalf of the defendant. He is not present today. He's home with 2 sick kids.
Okay, this is set for a status conference today. I know that the parties do have some additional hearings coming up with friend of the court, but in terms of property division, Ms. Richards, can you kind of tell me where things are at in that regard?
Yes, Your Honor. We recently had mediation. We were unable to reach a full settlement. However, we did agree to go back to mediation in August after the friend of the court hearings.
Okay, Mr. Blumberg?
Yeah, Judge, that's correct. We spent 3 hours fighting over personal property, which was not a terribly useful use of everybody's time, but we have agreed to go back.
Okay. I'm thinking then the court should set this for another hearing in September. Ms. Richards, does that sound acceptable?
Yes, Your Honor. We also would like, if we can't reach a agreement at the mediation in August, for this to be set for a bench trial, but I guess we can go over that at the status conference in September.
Okay, Mr. Blumberg?
That's fine, Judge.
Okay. All right, so the court will set this for a status conference for September. We'll see what, if any, issues remain at that point, and I think that'll help us, kind of determine how much time we would need if there hasn't been a full agreement to resolve any issues that remain outstanding. So we'll send out notice of the date and time of that hearing, and both parties can disconnect. Mr. Blumberg, I'm just going to leave you connected and then bring in Mr. Grote for the other 9 o'clock hearing.
Very good. Thank you.
Okay, thank you. Mr. Grote, are you able to hear me okay?
Yes, good morning, Your Honor.
Okay, good morning. We'll go on the record in Meyer versus Meyer. This is file number 2419940. If I could have both counsel put your appearances on in this file, please.
Yes, good morning again. Elliot Blumberg on behalf of the plaintiff.
Travis Grote on behalf of the defendant.
Thank you. This is set for a status conference today. I think it's been maybe 3 or 4 months since we were on the record for a scheduling conference. Mr. Blumberg, can you tell me the status of this file today?
Sure, Judge. We have a evidentiary hearing scheduled for the referee. The parties have started some dialogue in terms of trying to resolve the issues. We don't have an agreement as of yet, but we're working towards that.
Okay. All right. Has there been any progress towards getting mediation scheduled?
Yeah, well, I think we've agreed on a mediator. I'm not sure if it's been scheduled yet or not, candidly.
Okay. All right. Mr. Grote, anything that you wanted to add to that?
I would just add, Your Honor, we did actually mediate with Jerry Shuffalo on April 28th. But we weren't able to come to a full resolution at that time, but we have been communicating. I received communication from Mr. Blumberg. I know that the parties have also been communicating since that mediation, attempting to resolve all the issues.
Okay. Mr. Blumberg, any suggestions for how you want me to schedule this going forward?
Well, Judge, I think another status conference at the end of July would be helpful. I think hopefully we'll either have a resolution where we will have had an evidentiary hearing on the custody issues.
Okay, Mr. Grote.
I would agree. The evidentiary hearing, I believe, is scheduled for July 30th. So perhaps the first week or two in August might make sense for the next status conference with you, Your Honor. Obviously, if we come to a resolution, then I think the plan would be to notify your office and attempt to get a date for a pro-con before then.
Okay. All right, so I'll set this for a status conference on my motion day in August, which will be the first full week of August, the Monday of that date. And we'll go from there. Mr. Blumberg, anything else I can address for your side today?
No, Judge, thank you.
Mr. Crowe?
No, Your Honor, thank you very much.
Okay, and then Mr. Blumberg, I see you're also on the 9:15. I don't see the other parties yet on that. So I'll just put you on hold for a minute and then we'll get started with that as soon as we're ready.
Okay, thank you, Judge.
Thank you.
Have a good day.
See you,
Thank you.
Travis.
Mr. Blumberg, do you have Ms. Turner there with you?
I do, Judge. She is
Okay.
right here.
Okay, great. Mr. Turner, are you able to hear me okay?
I am. Can you hear me?
Yes, thank you. Okay, we'll go on the record now in Turner versus Turner. This is file number 2419678. The record should reflect that Ms. Turner is present with her counsel, Mr. Blumberg. Mr. Turner is also present on his own behalf, all parties by Zoom. I have this set as a date to enter a final judgment of divorce in this case. Mr. Blumberg, is that how you and your client wanted to proceed?
Yes, Judge. I think the parties have both signed the proposed judgment. The front of the court has approved it. We would like to be able to go forward with proofs today so you can finalize this matter.
Okay, Mr. Turner, is that how you want to proceed as well?
Yes, Your Honor.
Okay. Ms. Turner, I'm going to place you under oath, and then Mr. Blumberg's going to be asking you some questions. Raise your right hand, please. Do you solemnly swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Blumberg, proceed whenever you're ready.
Thank you, Judge. Lacey, can you give your full name for the record?
Lacey Elizabeth Turner.
And you are the plaintiff in this action for divorce, is that correct?
Yes.
On April 21st of 2024, you filed a complaint in the Otsego County Circuit Court for a complaint for divorce. And in it, you allege that on May 8th of 2022, you married Michael Turner in Otsego County, Michigan. Is that correct?
Yes.
And that ceremony was performed by an individual who was authorized to perform marriages. Is that correct?
Yes.
And your name prior to that marriage was Lacey Parker. Is that correct?
Yes.
And one of the things you're asking for today is the restoration of your maiden name. Is that correct?
Yes.
Okay. At the time that you filed your complaint, you claimed that you had been a resident of the state of Michigan for at least 180 days immediately preceding the filing. Is that correct?
Yes.
And you were also alleged that you've been a resident of Otsego County for at least 10 days immediately preceding your complaint. Is that correct?
Yes.
There are 2 children born of this marriage. Is that correct?
Yes.
That would be Milo and Jackson.
Yes.
And that you and Mr. Turner have come to an agreement after a evidentiary hearing in this matter, whereby you're going to have both sole physical and sole legal custody of those children. Is that correct?
Yes.
There has been a parenting time schedule that's been agreed to as a result of that evidentiary hearing. Is that also correct?
Yes.
In your complaint, you allege that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed, and there remains no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed this action?
Yes.
And is that true today?
Yes.
Again, you and Mr. Turner have come to an agreement as to the disposition of the assets of the marriage. Is that correct?
Yes.
There is no real estate or real property that's being divided, correct?
Correct.
There is some personal property, and you and he have already agreed how that's to be divided. Is that right? In terms of those vehicles, you have received the vehicles that you are to be receiving,
Yes.
and Mr. Turner has received those that he is receiving. Is that correct?
Yes.
You understand that you are not seeking spousal support, nor is Mr. Turner in this case, and that you're not going to be able to come back at a later date, nor is Mr. Turner, to ask the court to revisit the issue of spousal support.
I understand.
Okay, spousal support is forever barred. Okay? In terms, again, of the personal property and the division, each of you have that you're going to receive. Is that correct?
Yes.
Do you believe that the custody and parenting time arrangement in this case is in the best interest of your children?
Yes.
And as far as the division of assets and liabilities, do you believe that's also fair and equitable?
Yes.
Are you currently pregnant?
No.
Thank you. Judge, I believe that resolves all of the issues, accurately states the terms of the judgment, and we would ask the court to adopt that and sign the judgment of divorce.
Thank you. Mr. Turner, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Mr. Turner, were you able to hear all the questions that Mr. Blumberg asked Ms. Turner?
Yes, I did.
Were you able to hear all of her answers?
Yes, I was.
Do you have any reason to believe that any of the answers that she gave were untrue?
No, I have no reason to believe that.
Okay, and did you hear when Mr. Blumberg was asking her about the custody and parenting time provisions regarding the children?
Yes, I did.
And do you agree with those?
Yes, I do.
And then did you hear Mr. Blumberg asking Ms. Turner about how the property was going to be divided up?
Yes, I did.
And do you agree with those statements as well?
Do.
And you understand, as he indicated, that that neither you or Ms. Turner could come back later and ask the court for spousal support?
Yes, I understand.
Okay. All right. The court finds that the statute, I'm sorry, Mr. Blumberg, did you have any questions for Mr. Turner at all?
No, I do not, Judge. Thank you.
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties in this case. The court has reviewed the proposed judgment and finds that it's generally equitable and pertains all the provisions required by statute. The court will sign that judgment of divorce along with the support order. Mr. Blumberg, anything further from your side today?
I don't believe so. Thank you, Judge.
Mr. Turner, did you have any questions at all?
No, I don't.
Okay, all right, thank you. That concludes this hearing. And all parties are free to disconnect at this time.
Thank you.
Thank you.
All right, ma'am, are you Kara Fable?
Nope, this is Michael Fable.
Okay. I think I have Miss Fable connected. Miss Fable, is that you?
Nope, this is Michael Fable.
Yes, sir. I've got you, but I'm trying to determine whether I have Miss Fable as well.
Gotcha, sorry.
That's okay. Miss
I'm
Fable,
here.
are you? Okay, great. All right.
I'm
So
here.
thank you. We'll go on the record in Fable versus Fable. This is file number 2419899. The record should reflect both parties are present by Zoom video today. I have this set as a date to enter final judgment of divorce, which the parties have submitted to the court. Mr. Fable, is that how you wanted to proceed?
Yes, sir.
And Ms. Fable, is that how you wanted to proceed as well? Ms. Fable, is that how you wanted to proceed?
Yes.
Okay. I'm going to ask that you both
Yes.
raise your. Thank you. I'm going to ask that you both raise your right hands, please. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes. Yes.
Thank you. Thank you. Mr. Fable, I've got some questions that I need to ask you as the party who filed for divorce in this case. The questions that I'm going to be asking are the ones that I'm required to ask to establish the grounds for divorce under Michigan law. My
Okay.
first question is, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
That's true.
At the time that you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
Yes, I have.
Had you been a resident of Otsego County for at least 10 days?
Yes, I have.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes, it was.
Does that remain true today?
Yes, it does.
There were two minor children, or there are two minor children that were born of the marriage. Is that correct?
That's correct.
And under this judgment of divorce, you and Ms. Fable would be sharing joint legal and physical custody of the children, and you both would have an equal number of overnights with them. Is that correct?
That's correct.
You and Ms. Fable have already agreed on the division of any assets or debts of the marriage. Is that correct?
We have, yes.
And you are not asking for spousal support or alimony. Is that correct?
That's correct. I am not.
And you understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, sir.
Ms. Fable, have you heard all the questions that I asked Mr. Fable?
Yes.
Have you heard all of his answers?
Yes.
Do you have any reason to believe that any of the answers he gave were untrue?
No.
Are you currently pregnant?
No.
And do you agree with the joint physical and legal custody of the children and equal number of overnights?
Yes.
And do you agree that you and Mr. Fable have already divided up any assets or debts between the two of you?
Yes.
And you understand that you are also not going to be receiving any spousal support?
The child support?
Spousal support or alimony?
Oh, okay. Yeah.
Yeah.
Sorry.
That's okay. And you understand that you're waiving that forever and that you would not be able to come back later and ask the court for that?
Yes.
And then you're asking to have your last name changed, is that correct?
I kind of wanted to stay his last name if the hits are okay for him.
It's really your choice, Ms. Fable. The judgment indicates you're asking to have your last name changed, but if you don't want that, I can cross that part out.
No, if you
Okay,
don't mind.
I just want to be clear on, you do not want your last name changed.
Yeah.
Okay. So I'll cross out that provision then. Okay, all right. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court's reviewed the proposed judgment, finds that it complies with statute and court rule. The court will grant the divorce. I'm signing that today, so your divorce is final as of today. And Mr. Fable, do you have any questions at all?
No, sir.
Ms. Fable, do you have any questions?
No.
Okay. All right, thank you. That's all for this hearing today, and you're both free to disconnect at this time.
Thank you.
Yeah.
Hi there. Who do you guys have?
Goodman will be the first one we have,
Goodman?
or is that
Is
not
this,
right?
is this for Kalkaska case?
Yes.
Or hold on a second. Goodman. That sounds familiar. Hold on. Give me 1 second here.
You're good.
Okay, is that Gary? Oh, no, I'm sorry. Okay, so I think we might have a mix up here. My day for Kalkaska is tomorrow.
Oh, okay.
So you're probably looking at maybe tomorrow's docket for Tuesday.
Okay. Yeah. I don't know. I was just told to fire the Zoom up. So you don't have anybody for Kalkaska today?
No, but I definitely have Mr. Goodman and probably a bunch of others for tomorrow.
Okay. All right.
So
Thank you.
let's reconnect tomorrow.
Okay.
All right.
Bye.
Thank you.
Yep.
Okay. Okay, we'll go on the record in Peters versus Peters. This is file number 2419704. Ma'am, you're Hannah Peters, is that correct?
Correct.
Okay, and this hearing was set for 9:45. It's now 9:48. I do not see Mr. Peters present, but we do have Ms. Peters present. This was set for a final hearing today. The court spoke with the parties back in May. They were supposed to attend the SMILE presentation and submit a judgment to the court. I do have a note here, Ms. Peters, that you appeared at the front of the court office on Friday afternoon and with a proposed judgment, which could not be approved because you had not yet attended the SMILE program. And then I have a note here indicating that you told the caseworker that she was wasting your effing time.
Oh, no, sir. I did not say effing time. I actually said this is a waste of my time. I was not told previously that I would have to have that SMILE program done before they could sign off on the judgment papers. And so I was not aware that that would not be signed off at that time. I feel like I've been getting a little bit of a runaround when it comes to the front of the court. I do have a SMILE program set for tonight through Kalkaska. That is the only thing holding it up, and I'm not really sure why, because I've talked to many people and nobody else has had to do the SMILE program, and I've had to do the SMILE program before. I've already been through it, and so I guess like it's just, and it's only once a month, which is really hard for me to get to, and I have 2 kids and a full-time job. My kids were sick the last time I had the SMILE program, and I was not able to make that one, and so this was the next one. And unfortunately, it was for tonight.
Okay, so just want to clear a couple of things up. First of all, you were told multiple times that you had to attend the SMILE presentation, including by me at the last hearing in May on the record. So that's incorrect. Everybody who goes through a divorce with minor children has to attend the SMILE program. So whoever's telling you that is incorrect, and you're aware of that if you've been through it before. This is now the 5th hearing that I've had with you and Mr. Peters since January, where both of you have been repeatedly instructed about what you need to do. So claiming that you didn't know what you needed to do and that you haven't had 5 months now to attend one of these is just incorrect. And we're not going to tolerate you being rude to staff because you're not doing what you're supposed to be doing when you know what you're supposed to be doing. And I get that you're frustrated, but the fact that you haven't done what you need to do and what everybody going through a divorce needs to do is not a reason to take that out on the people who are just telling you what they need you to do so that we can take care of the business that you want to take care of. You're the one that filed for the divorce in the court. We didn't ask you to come in and get a divorce. You're asking the court to take care of this business for you, and we're telling you what we need you to do in order to do that. And if you're not going to do it, I'm not going to keep scheduling hearings and wasting my time. So I'm going to give you one more opportunity. If you haven't taken care of what needs to be taken care of by July, then I'm just going to dismiss the case and you can refile it and start all over again. So the ball's in your court at this point. Do you have any questions?
No, I do not.
Okay. All right. Thank you. That's all for this hearing today, and you're free to disconnect at this time. Mr. Blumberg, do you have Mr. Ferris there with you?
I just put him in the waiting room. I'll go get him.
Okay, great. Thank you. And Ms. Ferris, are you able to hear me okay?
I can Okay.
Okay.
Can you hear me okay? I got my AirPods in.
Yes, I can. Thank you.
Thank you.
Okay, we have both parties present. We'll go on the record now in Ferris versus Ferris, file number 2419904. The record should reflect that we have Ms. Ferris present today by Zoom video. We also have Mr. Ferris present along with his counsel, also by Zoom video. This is set as a status conference in this case today. Mr. Blumberg, on behalf of plaintiff, can you tell me where things stand?
Sure, Judge. Regrettably, there have been some most recent events that have caused some concerns as it relates to custody and parenting time. So while I thought most of the issues were resolved, I think we're going to have to go back in front of the referee to address some rather serious custody issues.
All right, is that what we have scheduled for? It looks like there's a hearing set for June 25th, or is that on a different aspect?
It may be a different aspect, but certainly at that time we will initially address those concerns, and I'm assuming we'll have an evidentiary hearing soon thereafter.
Okay, how about in terms of division of property?
Again, I met briefly with Ms. Ferris at my office. She is unrepresented, and I was of the impression that the parties had resolved those issues.
Okay. All right, Ms. Ferris, first, just as to the division of property and assets and debts, what's your view on that?
We were square on that also. I wasn't even aware until the last court date that anything was being brought up until the last court date. And then I met with his lawyer, and that's when he wasn't even quite sure what for property, because he wasn't at the time informed of the property that was supposed to be divided.
Okay, but from your standpoint, you think that you and Mr. Ferris have agreed on those kind of things?
I would say so.
Okay. All right, so I guess Mr. Blumberg and Ms. Ferris, my suggestion would be for the court to set this for another status conference following friend of the court hearing. I would propose to set that out like 60 to 90 days. So in case there is an evidentiary hearing that would need to be addressed by the referee, that parties would have time to do that. Do you have any objection to that, Mr. Blumberg?
No, Judge, that would be appropriate.
Okay, Ms. Ferris, do you have any objection to that?
I don't. Can our divorce can't be finalized and the parenting time a whole different thing, or is that all one?
It all has to be resolved together. So even if we have, no disputes about the division of the property, we need to have things settled in terms of custody and support in order to finalize everything. So they're two separate pieces, but they all have to come together at the end.
Okay.
Okay, so I'll send out a notice of the date and time of that hearing for the status conference at 60 to 90 days out. And we'll go from there. Mr. Blumberg, anything further from your side today?
Judge, only that if the parties were able to come up with an agreement between now and then, we would certainly inform the court, and then we can move towards a judgment.
Yeah, if that gets settled before then I'd be happy to get this on for hearing as soon as the parties are ready. Ms. Ferris, did you have any questions at all?
I do not. Until we have parenting time, because my parenting time starts again Wednesday, which I'm sure he's going to try to withhold the children. Those current parenting time still withstands, right? I can have my children on Wednesday.
Yeah, there hasn't been any interim orders issued by the court. So whatever is currently in place is what's in place. So
Okay.
Parties should abide by that order unless.
Thank you. I wanted to confirm that.
So, okay.
Other than that, I don't have any other questions.
Okay. All right. Thank you. That's all for this hearing today. Mr. Blumberg, I'm just going to put you on hold for a minute because I think you have the next case up as well.
I do. Thank you.
Thank you.
Howdy.
Okay, Mr. Blumberg, do you have Mr. Van Til there with you?
Yes, I do, Judge.
Okay, Miss Van Til, are you able to hear me?
Yes, sir.
Okay, we'll go on the record in Van Til versus Van Til. This is file number 2520004. The record should reflect all parties are present by Zoom video. This is set for a status conference today. The parties, I think at our last hearing, wanted some time to see if they could settle the matter. Mr. Blumberg, from your side, can you tell me where things are at?
Yes, Judge. Regrettably, the parties have not been able to resolve the issues in the case. And the issues are basically personal property and this premarital IRS obligation of Miss Van Til's. So those are the issues that still remain unresolved.
All right, do you have any objection to the court ordering community mediation?
No, did we already do that? I'm speaking to my client. Have you guys been to mediation yet?
Not that I know.
Okay, no, they have not, Judge, so that would probably be fine.
Okay. Ms. Van Til, do you have any objection to going to mediation to see if we can get these issues resolved?
No objections, Your Honor. I'd be okay with mediation.
Okay, so the court will refer this to community mediation. Ms. Van Til, just so you're aware, that's a process where you will all sit down with an independent third party who will try to, negotiate an agreement between the parties. Neither side's required to reach any type of agreement through that process, but they do try to facilitate that to look for common ground. That's typically done remotely. So it would be by Zoom, like types of hearings that we've been doing here in court. And they will contact you and Mr. Blumberg to work out a date that's agreeable for both of you. So please make sure that you follow up with them when they contact you, okay?
Yes, Your Honor.
And then we'll set this for a status conference. The court will allow 60 days for that to occur. If the parties are able to reach an agreement, then we can finalize the divorce at that next date. If not, then we can see where we need to go in order to get things resolved. Mr. Blumberg, anything else I can address for your side today?
No, thank you.
Ms. Van Til, do you have any questions at all?
No, Your Honor.
Okay, thank you. That's all for this hearing today, and both sides are free to disconnect at this time.
Thank you.
Okay, looks like we have both parties connected, so we'll go on the record in Corson versus Corson. This is file number 2520005. And I have this set for entry of a final judgment of divorce today. And Ms. Corson, is that how you wanted to proceed?
Yes.
And Mr. Corson, is that how you wanted to proceed as well?
Yes, sir.
Okay, I'm going to ask both of you to raise your right hands. I'll put you both under oath, and we got some questions for each of you. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
I do.
Thank you. You can lower your hands. Ms. Corson, as the party filing for divorce, my questions are going to start with you. Ms. Corson, you filed the complaint for divorce and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and you could not come back later and ask the court for that.
Yes.
All right, and according to the judgment, you and Mr. Corson have already divided up any personal property or debts, and that you would each be responsible for any debts that are in your own name. Is that true?
Yes.
And that you don't own any real estate or real property together. Is that true?
Yes.
And you're asking to have your last name changed. Is that correct?
Yes.
Okay. Mr. Corson, have you heard all the questions that I asked Ms. Corson?
I have.
Have you heard all of her answers?
I have.
Do you have any reason to believe that any of the answers she gave were untrue?
No.
And you are also not going to be receiving any alimony or spousal support. You understand that you would also be waiving that forever and could not come back later and ask the court for that.
I do.
And do you agree that you and Ms. Corson have divided up all the property and debts and that you would each be responsible for any debts in your own name?
I do.
And that you don't own any real estate or real property together?
Yes, no, we don't. I don't.
Thank you.
Yes.
The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce, and I've signed that judgment, which contains all the provisions required by statute. So your divorce is final as of today. Ms. Corson, that means that from today forward, your last name will be legally changed. So you'll need to change your identification and other documents. You can get a copy of the judgment of divorce at the clerk's office here in Gaylord, because you'll likely need that in order to change those kind of things regarding your name, okay?
Yep.
Ms. Corson, do you have any questions at all?
I do not.
Mr. Corson, do you have any questions?
I do not.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you, Judge.
Thank you.
Whoever's signing in on the Motorola device, can you tell me your name, please?
My name is Avina Snyder.
Ms. Snyder, okay. All right, we'll go on the record in Snyder versus Steffes. This is file number 25-20006. The record should reflect that Ms. Snyder, the plaintiff, is present today by Zoom video. And Ms. Snyder, I have this as set today to enter a final judgment of divorce in this case. Is that how you wanted to proceed?
Yes, please.
Okay. I do need to note for the record that Mr. Steffes was served with the summons and complaint in this matter. He did not file an answer or otherwise defend. He was defaulted back in May, was provided notice of the default as well as notice of the date and time of today's hearing, which was set for 10:30. It's now 10:36. He has not appeared. So we can move forward. So Ms. Snyder, I'm going to place you under oath. I've got some questions that I need to ask you. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you could raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I solemnly swear.
Thank you. You can lower your hand. You filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the proposed judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
I understand.
And the judgment indicates that there are no debts to be divided and that each of you has kept whatever personal property was in your possession. Is that correct?
Yes, that's correct.
And you don't own any real estate or real property together?
No.
Okay. All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of the plaintiff. The court has reviewed the proposed judgment, finds that it is equitable and contains all the provisions required by statute. The court will grant the divorce. So your divorce is final as of today. Did you have any questions at all?
No, I did not.
Okay. All right, that's all for this hearing and you're free to disconnect at this time.
Thank you. Have a good day.
Thank you. Okay, sir, is your name Justin Patton?
Yes, sir.
Okay. All right, this is Patton versus Patton. This is file number 2519992. The record should reflect that Mr. Patton is present today by Zoom video. Ms. Patton is not present. This had been set for a date to enter the default judgment of divorce. So Mr. Patton, did you want to proceed with finalizing the divorce in this case today?
Yes, sir.
Okay. All right. The record should reflect that it appears that Mr. Patton was properly served with the notice, with the summons and complaint. He didn't file an answer, so a default was filed against him. However, Ms. Patton is the party not appearing today for the hearing, which was set for 10:30. It's now 10:40. So given her non-appearance, the court finds that it would be appropriate to nonetheless proceed with judgment in this case. Mr. Patton, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, thank you. You can lower your hand. Mr. Patton, have you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
And you do not reside in Otsego County, is that correct?
I did for a little bit.
Okay. Did you reside in Otsego County for at least 10 days?
Yes.
Okay. And to your knowledge, does Ms. Patton Shauna, does she still reside here in Otsego County?
Yes, sir.
Okay. In the complaint for divorce in this case, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that your marriage could be preserved.
Yes, sir.
Is that true?
Yes.
Okay. If the court were to decline to grant a divorce, is there any chance that your marriage could be reconciled?
Honestly, I have no idea. I haven't talked to her in months.
Okay. All right. Under the judgment of divorce in this case, you would not be receiving any kind of alimony or spousal support. You understand that you would be waiving that forever and that you cannot come back later and ask the court for that?
Yes, sir.
Do you own any real estate or real property with Ms. Patton?
No.
Okay. Have the two of you already divided up any personal property between the two of you?
Yep.
Okay. And have you already divided up any debts, or are you each going to just be responsible for whatever debts are in your own name?
I believe it's just we're going to be responsible for whatever's in our names.
Okay. Okay. Are there any other issues regarding the division of any assets or debts that need to be decided by the court?
Nope.
Okay. All right. The court finds that the statutory grounds for divorce have been met by the testimony of Mr. Patton. Again, the court notes for the record that Ms. Patton did not appear today. So the court will sign the default judgment of divorce. So your divorce is final as of today. If you wanted a copy of this for your records, Mr. Patton, you could contact the clerk's office here in Gaylord and ask them to send you a copy, okay?
Okay.
Do you have any questions at all?
No, sir.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
All right. Thank you. Bye.
Thank you. Okay, if I could have you both on mute, please. Ma'am, are you Miss Comfort?
I am.
Okay, and sir, you're Mr. Comfort, is that correct?
Yes, sir.
Okay, we'll go on the record now in Comfort versus Comfort. This is file number 2520034. The record should reflect that both parties are present by Zoom video today. I have this set today for entry of a consent judgment of divorce. Ms. Comfort, is that how you wanted to proceed?
Yes, sir.
And Mr. Comfort, is that how you wanted to proceed as well?
Yes, sir.
Okay. I'm going to place both of you under oath. I've got some questions that I need to ask each of you. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would please both raise your right hands. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir.
Thank you. You can both lower your hands. Ms. Comfort, my questions are going to start with you as the party filing for divorce in this case. Ms. Comfort, you signed a complaint for divorce in this case. Is that correct?
Yes, sir.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
Had you been a resident of Otsego County for at least 10 days?
Yes, sir.
In that complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes, sir.
Does that remain true today?
Yes, sir.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No children.
Are you currently pregnant?
No, sir.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. Is that correct?
Correct.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
I understand.
Okay. And you and Mr. Comfort entered into a property settlement agreement. Is that true?
That is true.
Okay. And that was signed and notarized back on February 16th of this year. Is that correct?
That is correct.
Did you review all the terms of that agreement prior to signing that?
I did because I wrote it.
Okay. And in signing that agreement, did that indicate your assent to agreeing to all the terms and carrying out all the terms of that property settlement agreement?
Yes, sir.
Okay. And does that settlement agreement dispose of all the issues regarding the division of assets or debts of the marriage?
Yes, sir.
And you are asking to have your last name changed, is that correct?
Correct.
Okay, thank you. Mr. Comfort, have you heard all the questions that I asked Ms. Comfort?
Yes, sir.
And have you heard all of her answers?
Yes, sir.
Do you have any reason to believe that any of the answers she gave were untrue?
No, sir.
Under that property settlement agreement and the judgment of divorce, you also would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you could not come back later and ask the court for that.
Yes, sir.
And have you read all the terms of that property settlement agreement that you also signed back on February 16th?
Yes, sir.
And in signing that document, does that indicate your willingness to abide by all the terms and carry out the terms of that property settlement agreement?
Yes, sir.
And do you agree that that resolves all issues of the division of assets or debts of the marriage between the two of you?
Yes, sir.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court has reviewed the judgment of divorce as well as the property settlement agreement. Finds that it is equitable and otherwise contains all provisions required by statute. The court will sign that judgment of divorce today, so your divorce will be final as of today on the terms indicated in that property settlement agreement. That also means, Ms. Comfort, that from today forward, your last name will be legally changed So you'll need to get a copy of this judgment of divorce so that you can change your identification and other documents, okay?
Thank you, sir. Will that be mailed to us or do I need to come pick it up?
Leanne, do you know if that's something that's gonna be mailed out? There's multiple copies here.
Yes, I'll mail it out to each one of the parties.
Okay. Ms. Comfort, did you have any other questions?
No, sir.
Mr. Comfort, did you have any questions?
No, sir.
Okay. All right. Thank you. That's all for today. And you're both free to disconnect at this time.
Thank
Thank
you.
you.
Mr. Baber, can you hold on for just 1 second? I've got to address something real quick before I call your case.
That's fine. Thank you, Judge. I'll hold.
Okay, thanks. Mr. Slough, good morning.
Morning.
I just wanted to touch base with you. We did set this, you're appearing on a debtor exam, is that correct, or creditor?
Yeah, that's correct. Yeah, we did not accomplish service, so we're going to need to adjourn it to a different date, and I'll just change the date on the subpoena if that's acceptable.
Okay. Yep. Let me check with our court officer just to make sure that nobody appeared here in person this morning.
Yep.
And then I'll get right back to you. Okay.
Okay. Sounds great. Thank you.
Thank you. Okay, Mr. Baber, we'll call your case. This is Crabtree versus Conradi, case number 0812760. The record should reflect that Mr. Baber is present today by Zoom video. This was set for hearing at 11 o'clock. It's now 11:03. No one else has appeared in response to this motion. And Mr. Baber, this is your motion to withdraw. I did have an opportunity to review your motion in brief as well as the proposed order. Was there anything you wanted to state in support of that here today?
No, Your Honor. I can state that originally I did serve the prosecutor's office, and correctly they notified me that this was with the friend of a court. So on May 19th, I sent the notice to the friend of the court via certified mail on that date. It doesn't appear that they are here. I don't believe that there's any objections to my motion. Other than that, I'm just going to rely on the brief in support of my argument for the motion to withdraw.
Okay, the court finds that there is an adequate basis to support the motion to withdraw. The court will grant the motion based on the reasons stated by Mr. Baber in that motion. I'll sign the proposed order, which the court wants to note for the record does include a provision that MIDC will appoint a new counsel to represent Mr. Conradi in this child support collections matter. So I signed that order today. Mr. Baber, anything else I can address for you?
No, Judge, that is it for the day. Thank you.
Okay, thank you. That's all, and you're free to disconnect at this time.
Thank you, Judge. Have a good rest of your day, sir.
Too. Thank you. Okay, Mr. Slough, if you're there, I'm ready to call your matter. Okay, great. This is Skronsky versus Savo Valley Forestry, file number 2419709. Mr. Slough is present today on behalf of plaintiff. This had been scheduled for debtor exam. Mr. Slough, for the record, can you state how you'd like to proceed?
Yeah, I would ask the court adjourn it to a later date, perhaps early August, so that we can modify the date on the subpoena and continue with attempts to serve Mr. Stephen Cobb.
Okay, I'm just going to adjourn it without date. And once you've been able to obtain service, if you can just contact Jennifer and ask her for a new date, we'll get it on the docket right away.
Okay, do you have any objection, Judge, to me contacting her and getting a date to put, I mean, the problem is if I serve him and there's no date on the subpoena, then there's no accountability for him to show up on a particular date or time, if you see what I'm saying.
Yep, absolutely. Yeah. So certainly, if you need to get that date ahead of time so that you can specify that.
Great. Yeah, that's what I'll do. I'll contact your clerk and get that date.
Okay, very good. Thank you.
All right. Thank you.
Oh my gosh.
Sir, on the Samsung device, can you tell me your name, please?
Al Baum Jr.
Okay. And ma'am, are you Miss Baum?
Yes.
Okay, great. All right, we'll go on the record now in Baum versus Baum. This is file number 2520010. The record should reflect both parties are present today by Zoom video. I have this set for entry of a judgment of divorce. Ms. Baum, is that how you wanted to proceed today?
Yes, Your Honor.
And Mr. Baum, is that how you wanted to proceed as well?
Yes, sir.
Okay. I'm going to place both of you under oath. I've got some questions that I need to ask each of you. The questions that I'm going to be asking are those that I'm required to ask in order to establish the grounds for divorce under Michigan law. So if you both would please raise your right hands. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you. You can lower your hands. Ms. Baum, since you filed for divorce in this case, my questions are going to start with you. You filed the complaint for divorce in this matter and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the proposed judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Under the proposed judgment, you would each be responsible for any debts that were in your own names. Is that correct?
Yes.
And you don't own any real estate or real property together?
No.
Okay. And then under paragraph 18 of the judgment, there's some statements dividing up some personal property between the two of you. And is that how you want the court to divide that property?
Yes, those have already been titled in the appropriate names and things.
Okay. All right. Thank you. And you're asking to have your last name changed. Is that correct?
Yes.
Okay. Thank you. Mr. Baum, have you heard all the questions that I've asked Ms. Baum?
Yes, I have.
Have you heard all of her answers?
Yes.
Do you have any reason to believe that any of the answers she gave were untrue?
No.
Under the judgment, you also would not be receiving any alimony or spousal support. You understand that you also would be waiving that forever, would not be able to come back later and ask the court for that.
Yes.
And do you agree with the division of property as stated in the judgment of divorce?
Yes.
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court finds that the judgment is equitable and contains all the provisions required by statute. I signed that judgment of divorce with today's date, so your divorce is final as of today. Ms. Baum, that means that your name is also legally changed as of today, so you need to make sure that you change your identification and other documents, okay?
Okay, when am I able to pick up that paper to be able to go to Secretary of State?
You should be able to pick that up probably after lunchtime today, anytime this afternoon.
Okay, thank you.
Do you have any other questions?
No.
No.
Mr. Baum, did you have any questions?
No, sir.
Okay, thank you. That's all for this hearing today, and you're both free to disconnect this time.
Thank you.
Thank you.
Okay, looks like we have everybody connected, so we'll go on the record in Buyer versus Gambino and State Farm. This is file number 2520030. And if I could have counsel put on your appearances, starting with plaintiff.
Good morning, Judge. This is Ryan Ford on behalf of the plaintiff.
And I'm Mark Williams. I'm here on behalf of Danielle Gambino.
Okay. And I see Miss Berlin is connected, but she doesn't have her. Let's see if we can get, we have one more counsel here on behalf of State Farm that we need to connect. Okay, well, let's at least get started. So Mr. Ford, as representative for plaintiff, can you just kind of give me just a brief outline of your claims and what you'd like to see for scheduling as we go forward?
Sure, Judge. So this is a combined no fault action and a combined auto negligence action. The no fault action, of course, is against State Farm, and the auto negligence action is against Ms. Gambino. And my client is alleging claims for some medical expenses and some replacement services and medical mileage. And then against Ms. Gambino, obviously non-economic pain and suffering damages are being claimed. It looks like I filed the case on 3/24 of this year. I sent out my initial disclosures and my interrogatories and requests for protection of documents on both defendants. I did receive State Farm's initial disclosures, although I did not receive their no-fault claims file. I'm still waiting on Ms. Gambino's initial disclosures to come through. And I think the answers to my discovery requests are coming up due. It's either tomorrow or Wednesday, but it's coming up shortly here. That's kind of where we stand at this point in the case. You know, in terms of like discovery, I always ask the court for 180 days. I always feel like it's a good idea to get more time in the beginning, then get less, and then have to come before the court on a motion and ask for some more time as we get deeper into the case. So I guess that's what I would request for discovery.
Okay. Are there any, kind of unique or complex issues in particular about this case that you think would affect the scheduling track, or just kind of a general outline? I
don't think there's any special circumstances that involve this case. It's a no fault case. It's a bodily injury case. I think it's a kind of a standard case, if you will, Judge. So I don't anticipate any surprises popping up. I can't guarantee that, of course, but this time I don't see any.
No, and that's fine. I just like to get a sense at the outset whether there's something really out of the ordinary about this particular case that I need to be ready for in terms of scheduling. So it sounds like that's not not the case here. Mr. Williams, is there anything that you want to request in particular in terms of scheduling?
No, I agree with Mr. Ford. I think 180 days for discovery is a suitable time period. I'll get our initial disclosures filed this week, and we're working on the discovery. I don't, unless there's something unusual, extremely unusual about the injury, I don't think there's anything strange. It's a rear end accident, so I don't think there's anything incredibly strange about the circumstances that's going to make discovery complex.
Okay. All right, so I'm just gonna kind of do my typical scheduling order here with that period of discovery that the parties have suggested. So we'll set aside 180 days for discovery. I typically require facilitated mediation within that 180-day period. I leave that to the parties to schedule that when they think, you know, discovery's at a point where that's gonna be beneficial. I do ask the parties to confer and agree on a mediator and notify the court. And that's in writing in the court's pretrial order, so you'll be able to see that. Is there any objection to ordering mediation within that time of discovery, either of you?
Not for me, Judge.
No objection on our end either.
Okay. And then I will also set a dispositive motion for summary cutoff date 30 days after the close of discovery. And then I typically set it for a status conference around that time. If there haven't been any motions and the case hasn't mediated, then or settled, then we could talk about where we need to go in terms of scheduling from there. And obviously, if the case settles prior to that, then the court will take that date down. But along with the pretrial order regarding the dates that we've set forward, then I will also send out a notice of the date and time for that status conference. Mr. Williams or Mr. Ford, any other dates that either of you would like to request?
When does the court typically require the parties to submit their witness lists?
I usually don't set that as a preliminary matter unless the parties request it. Obviously, if it looks like we're going to trial, we'll set deadlines for final lists and so forth. But if you want to request dates for exchange of those kind of things, I'd be happy to put that in the order.
You know, I'll leave that up to the court's discretion. If, you know, Mr. Williams requests it, that's fine.
That's fine. I think we can cover it in our discovery requests and disclosures.
I used to put witness and exhibit list, those types of things in the pretrial order, but once the discovery rules changed, I found that the parties were ending up doing that anyway. So that's why I typically don't do it now, unless it's specifically requested. So, Miss Berlin, I've set forward some dates here. I know you're joining in late for the scheduling order, 180 days for discovery. Do you have any particular dates you wanted to request for scheduling?
Judge, a message just popped up. I guess her microphone was locked. Oh, okay.
I see. Okay, that's my fault. I thought I had it set to allow people to unmute themselves. I must not have clicked that button. So sorry about that.
No, that's okay. I'm so sorry that I don't know if it was a technology issue on my end, but I'm not quite sure where things have left off. I think I got added to this party a few minutes late.
Okay. So we have 180 days set for discovery. The court is ordering mediation to occur within that time, with the parties conferring and attempting to agree on a mediator and notify the court of that. A dispositive motion cut off 30 days after the close of discovery, and then a status conference around that time to see where things are at, which is my typical way of scheduling. That would go out into a pretrial order, along with the instructions regarding selection of mediator. So were there any other dates that you wanted to request?
Your Honor, does the court require a specific deadline for independent medical examinations, or is it sufficient that they just occurred during the course of discovery?
Yes, just during discovery. I usually don't put a deadline in the order.
Otherwise, no, I don't have any other scheduling order requests.
Okay. All right. So as I indicated, the court will send out a scheduling order with the dates that we've discussed here today, along with further instructions. The court will also send you a notice of the date and time for that status conference around the close of discovery. And that's all I have. Thank you. You're all free to disconnect at this time.
Thank you.
Thank you, Judge. Good seeing everyone.
Mr. Brown, I just wanted to see what case you're signing in on.
I believe this is Rut Camp. I got noticed there was a motion to transfer this case.
Okay, have you been appointed as the guardian ad litem in this? Is that your role?
Yes.
Okay, great. Awesome. Thank you.
I did file an appearance a couple of weeks ago.
Okay, I may not have seen that. I mean, I knew that was in the works, but. Okay, looks like we have counsel connected, so we'll go on the record now in Rep Camp versus Godiva, and this is file number 2419655. If I could just have counsel starting with the petitioner put your appearances on.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Rutkamp.
Mr. Blumberg, you're still muted.
Apologize for that. For the record, Elliot Blumberg on behalf of the respondent Brooke, who's appearing via Zoom from my office.
Larry Brown, guardian ad litem, appearing on behalf of Connor.
All right, thank you. We're on the record here today for a motion hearing filed by Ms. Godiva to have this case, I guess, transferred or reassigned to Judge Burmeister in Crawford County. I had a chance to review that motion as well as your response, Mr. Trush. So, Mr. Blumberg, anything you wanted to say in support of that motion today?
Yeah, I've not seen Mr. Trush's response.
Okay, I don't know, Mr. Trush, did you file that with Mr. Blumberg's office?
We did. I can send a copy of it to him again.
Looks like that was served back on May 23rd.
Was it sent via email or hard copy? I don't know. I haven't seen it.
It was sent via email. Let me.
Proof of service shows email, yeah.
Well, without knowing what the response is, Judge, I'm still prepared to go forward. I mean, I think our motion's fairly straightforward. This matter is a proceeding that affects a child. Mr. Rutkamp is attempting to extend the PPO on behalf of his son Connor in the as next friend. There have been court rules that have been amended and adopted that really address the issue whether there are other cases affecting the child, where there are pending custody cases in another court. And those have been cited MCR 3.204 and MCR 3.212. Again, this matter before you affects the child. I don't think there can be any argument about that. And these cases or the amendments to the court rules have been specifically in place to allow a judge that's hearing these other cases affecting the same parties, affecting the minor child, should be heard by the same judge. While we don't doubt that you can be impartial, this isn't a question of your bias or impartiality. Although I would indicate to the court did sign the extension of the PPO while the petition to extend was filed within the 3 days before the expiration of the PPO. I mean, I don't know if the court saw that or felt that, I don't know what the court's position was. But we're not here today to argue over the propriety of the PPO, but rather whether or not Judge Burmeister, who is presiding over the child custody case, the landlord-tenant case that affects the child, and another matter in Crawford County, whether or not for the sake of judicial economy and for the sake of that he is familiar with these parties and the issues that are before this court, whether or not this case should be transferred to Crawford County. And respectfully, we think that that would be appropriate at this point.
All right, thank you. Mr. Trush?
Thank you, Your Honor. I'm not going to go too far. I mean, again, our response, I think, largely speaks for itself. I think Mr. Blumberg cited the 2 different court rules. I don't think either one of them applies. The first court rule that he cites to is 3.204. One, I mean, the obvious answer here is that pertains to certain types of hearings, but specifically it doesn't pertain to a PPO hearing. It pertains to custody hearings. It pertains to family law hearings. It pertains to a variety of different hearings, but not a PPO hearing. I think more importantly, though, it also only pertains to new proceedings. I mean, this is a proceeding that was initiated a year ago. The motion, we're at a motion to extend it. I mean, it's not a new hearing. This is a continuation of a hearing that's been, a matter that's been in existence for a year. And frankly, one in which I don't think there's judicial economy in transferring it because this court has already ruled, meaning it's already made certain findings of fact that frankly, the new court would have to go through and make again. In addition to that, this court has appointed a GAL, which again, if it were transferred to another court, presumably the new court would have to appoint a new GAL, presumptively from their NA contract, which Mr. Brown isn't a part of, meaning that GAL would then have to go through the other proceedings and do all the things that Mr. Brown has done again. So I don't think there's significant judicial economy there. The second court rule he cites to is 3.212. Frankly, in that court rule, there's specific conditions that would allow for this sort of transfer to happen, and this is not consistent with those conditions. Specifically, it would identify that if one of the parties has lived in the county within the last 6 months, you shouldn't transfer the jurisdiction to another county, which is the circumstance that we have here, where Ms. Godiva has been in Otsego County, I think, for more than 6 months, but also presumably will be there for the foreseeable future because she's participating in the sobriety court program through the county, which requires her to maintain residence inside Otsego County. So again, for those reasons, I don't think either of those court rules provide the court a basis to transfer the jurisdiction here. Thank you.
Judge, again, since I've only now heard Mr. Trucia's response and the reasons why he's opposing this, I don't know whether Mr. Brown has done anything since his appointment. He's here today. Maybe we can hear from him. But certainly he would be available to perform the same services down in Crawford County as he is in Otsego. And we will figure out how he gets paid. Again, Judge Burmeister has already issued a personal protection order against Mr. Rutkamp. He's extended that for 2 years. Mr. Rutkamp is the person who is the next friend for Connor in this case. We have challenged that and will continue to challenge that. But we think it is more appropriate, given Judge Burmeister's history with these litigants and the child custody case is pending in Crawford County, that it would just make more sense for that court to hear this matter, along with every other case affecting these parties and those affecting the minor child. So if you're going to rule today, I guess I would just ask the court to allow me to review Mr. Trucia's responses before you did that.
Okay. Mr. Brown, do you take any position on this, or
I take no position on that. I have gone through the case files. It looks like and these things are pretty complex and very adversarial. So I have done that, and I'm still working on that to get the court a report. I still need to meet with Connor. But as far as transfer of the case, I take no position on that.
Okay. All right. Well, I guess my view, number one, is I don't think that the court rules are applicable, but not for the reason that Mr. Truce has indicated. The 46th Circuit comprises the 3 counties of Otsego, Crawford, and Kalkaska. And in Crawford County, Judge Burmeister is the presiding judge of the 46th Circuit Court Family Division for Crawford County. So he's acting as a circuit court judge of the 46th Circuit. So I don't view this as a transfer of jurisdiction, because the 46th Circuit Court has jurisdiction of both the PPO matter that was filed in Otsego County and the custody matter in Crawford County. So I don't view it as a transfer of jurisdiction or a transfer between courts that would need to satisfy any kind of court rule. I mean, I view this as a reassignment of judges. And typically under the local administrative orders, if there's a PPO filed and one of the presiding family court judges has jurisdiction over or has been assigned, I should say, has been assigned to a family court matter, then typically the PPO is assigned to that family court judge, because that judge has particular knowledge of what's gone on between the parties and may have already issued orders affecting custody and parenting time that could be affected by the issuance or non-issuance of PPO. So there's already a local administrative order in place that would have allowed, I think, even though this is a difference in counties, for this to be assigned to Judge Burmeister from the beginning. Obviously, that didn't happen. But I don't think it's a matter where the court would need to find grounds to transfer jurisdiction. Again, I think it's an issue of should Judge Burmeister be reassigned to the PPO matter because of his involvement in the family court matter. And I think there's some value to that because of that potential for conflicting orders to be entered by two different judges affecting the same issue, which is which party has access to Connor, and which party may be prevented from having contact with Connor, either because of a custody and parenting time order issued by Judge Burmeister as family division judge, or me as a circuit court judge with jurisdiction over the personal protection order. So I think the first thing that I'm going to do, and I've already made this inquiry, I just haven't had the communication yet, but I think even under the court rules, the court is required to communicate with Judge Burmeister about the most efficient way to handle these two matters. So I'm going to take the motion under advisement for purposes of today's hearing. I'm going to have communication with Judge Burmeister, and then I'll issue an order either granting or denying what I'm going to view as a reassignment of the judge, not a transfer of jurisdiction. Because I'm not making that decision based on the application of a court rule, which Mr. Blumberg may not have been fully able to challenge that. I don't think more time is necessary. I don't think because again, I don't think it's a matter of application of court rule. I think it's a question of should Judge Burmeister be reassigned this file given his previous involvement. So I'm going to do that within the next 7 days. That shouldn't take probably not even that long, but the court will issue an order within the next 7 days, either keeping the case or reassigning it to Judge Burmeister. If this court keeps the case, then Mr. Brown, you'll get a copy of that order as well. I'll just ask that you continue, if that's the case, to proceed with what you've been doing. If the court reassigns it to Judge Burmeister, then I'll include in that order some instructions for Judge Burmeister to communicate with you in terms of what he wants from the guardian ad litem going forward, if anything. So the court will get that order out to the parties again as quickly as I can. So
very good. Thank you, Judge.
Okay, that's all I have for today. All parties are free to disconnect at this time.
Thank you.
The court's morning docket. The court will be in recess.